I'm unmuted. What? Where's Bill? Marshall, you'll need to unmute.
Hear ye, hear ye, hear ye. The Honorable Chief Justice and Justices of the Supreme Court of Ohio. The Honorable Supreme Court of Ohio is now in open session pursuant to adjournment.
Good morning, ladies and gentlemen. Our first case is 2019-914 and 2019-1027, the State of Ohio versus LaShawn Pettis. For the appellant, Mr. Anselmo.
Good morning, and may it please the court, Mr. Heenan, Chief Justice O'Connor. My name is James Anselmo, and I represent LaShawn Pettis in this matter. And if I may, I'd like to reserve 5 minutes for rebuttal. This is a straightforward case calling for the statutory construction of RC 2913.61C1, which allows for the prosecution to aggregate theft-related offenses into a single count. At issue is whether a defendant convicted of multiple theft offenses committed in the same employment, capacity, or relationship to another, does RC 2913.61C1 permit the offenses to be aggregated when the victim is not an elderly person, disabled adult, or active duty service member, or spouse of an active duty service member? Stated another way, does RC 2913.61C1 only apply when the victim is an elderly person, disabled adult, or active duty service member, or the spouse of an active duty service member? The prosecution aggregated Mr. Pettis' theft offenses under the statute, even though the victims were not under those specific classes. Pettis claimed in the first district that the prosecution improperly aggregated his theft offenses because the victims weren't in those special classes. He claimed that this improper aggregation resulted in the prosecution trying him for more serious offenses than it could have had it not applied the aggregation. The prosecution contended that the offenses were properly aggregated, and the first district agreed. This court applies de novo review to this issue.
Counsel, let me ask you a question on the statute itself, 2913.61C1. Wouldn't your argument have more value if there was a comma between the words revised code and involving?
Actually, Your Honor, I would actually argue the fact that the comma placements, they could have easily, had they wanted to separate these and not include theft offenses, if they wanted them to be all encompassing and not related to the specific classes of victims, I think they would have used a period at the end of that first clause as they did in C2.
That was my question.
I'm sorry.
My question was, wouldn't your argument have more value if there was a comma between revised code and the word involving?
Oh, I see. Yes, Your Honor. I don't, because again, and I don't even think the prosecution is arguing that the victim or elderly person or disabled adult is limited to section 2913.3.1 or 2913.4.3. It's my understanding that they claim it applies to that clause after the period, section 2913.02 of the revised code period. I think they claim it applies for that entire section, beginning with or a series of violations. And I think, again, reading that entire phrase or sentence, they use when a series of offenses under section 2913.02 of the revised code, they repeat it again when applying to the other class of victims for service members. why would they do it twice if it wasn't meant to qualify for both of those classes of victims?
If you grammatically diagram the sentence, the word involving a victim really only relates to 2913.31 and 2913.43 on basic grammar grounds.
I guess, Your Honor, I would respectfully assert, though, when you look at the entire statute as required under Bryant, read the entire statute of a whole, again, I would argue that the preceding statutes are qualifying all that involving a victim who is an elderly person or disabled adult. I don't know if the comma is really necessary or not to qualify that entire phrases. Especially when you look at the fact that, again, they're repeating when a series of offenses under 291302, the revised code, they're repeating that twice before each of the qualifying victims. Otherwise, they'd be superfluous if it wasn't to be applied to each of the qualifying victims. And so I think looking at those, the entire statute as a whole, even without that comma placement, shows in favor of the interpretation that Mr. Pettis has. In particular, when you look at it in pari materia with C2, again, with C2, they clearly spelled it out that these are separate. Under C2, it indicates if an offender commits a series of theft offenses that involves a common course of conduct to defraud multiple victims, all the offenses may be tried as a single offense, period. And then in the next sentence, it says, it indicates that the statute is also triggered when certain theft-related offenses are committed against an elderly person or disabled adult. I mean, that's a clear situation, it sounds like, where they are indicating that series of theft offenses is all encompassing and not qualified by the character of the victims, because again, they're separating with a period. Here,
Counsel, doesn't the legislative history of the statute, given the fact that these special classified persons were added later, suggest that the theft related was meant to stand alone? Classification, the aggregation.
Your Honor, I would argue that the first district did mention that in their interpretation, and actually would argue that that was irrelevant because they claimed that the first district indicated that the statute was unambiguous. And in that situation, you are to look at the statute as written and you're not to look at legislative history. And perhaps—
What about the use of the word "or" in between these sections?
Whether it makes it ambiguous or not, or
non-ambiguous, that it's separating these different sections, and that these were meant to expand the amount of victims rather than clarify the whole statute. I mean, you agree at one time aggregation of theft under the facts related in this case would have been covered by the statute?
Under the previous statute, before they included those classes of victims. Okay. Again, going to legislative history, we can't really read into, given the plain language, under a plain language interpretation, we really can't read into, whether, why they added it, whether they added meant to keep it as originally written and just include.
Counsel, I think the question is, under the first iteration of this statute, would your client be aggregated?
Under the first iteration, it would apply. It is all encompassing.
Okay. All right.
But I guess, if I may, Your Honors, my point is legislative history would be irrelevant when looking at an unambiguous statute. We are to look at it as plainly applied and perhaps come to the conclusion that the legislature intended to make a full modification of the statute as unambiguous.
counsel. The C1 section uses 2913.02 twice. It uses it in the first part, which it retained from the prior statute or the prior iteration, and then it reiterates 2913.02 along with the other revised code sections when adding the elderly adults or disabled people. How is that ambiguous?
I would argue it's not ambiguous, Your Honor. And in fact, that emphasizes my point that repeating that twice in my argument meant that the legislature was trying to use these qualifying statutes to qualify the particular victim in the particular sentence. Otherwise, why repeat it twice?
Okay, counsel, you also read the C2 section to try to distinguish it from C1, but this was a theft by fraudulent check. Why doesn't C2 apply? And if C2 applies, how is your client even prejudiced?
Your Honor, on that matter, I would argue that the prosecution specifically stated on record that they were applying it under C1, jeopardy attached under C1, but no one ever argued that C2 applied. And so that issue really did not get preserved throughout the briefing or on appeal, in that matter. That may be something that could be addressed on a remand, but C2 was really never put an issue in this case. There could be arguments made about whether there were mergers or whether that these are all under a common course or what have you, but I would argue, Your Honor, that really isn't an issue that's been preserved in this matter.
Counsel, the fact that this is a conflict, that we have the 12th district ruling in one way, and then we have the 1st district another, how does that, would you address your statement that this is an unambiguous statute and we have two learned panels in two different districts coming to diametrically opposed conclusions?
Yes, Chief Justice. I would quickly respond by saying the cases that are in accord with Mr. Pettis's argument, Gibson out of the 2nd district and Phillips out of the 12th, Phillips is the specific one that's the conflict, specifically address the issue at hand, whether the statutes only apply to the particular class of victims that we're discussing. The other decisions out of the 8th and the 3rd, Greer and Williams, relied upon by the state as well, do not address that specific issue. They address specifically whether the offenses were committed in the same employment capacity or relationship to another. I would also point out that Greer relied upon the previous statute that did not have the specific class of victims that we see now. So it was applying a differently worded statute. And Williams relied upon Greer, which again was interpreting a different statute. So those would be my two answers to that, Chief Justice.
Thank you.
If there are no other questions, may I reserve the rest of my time for rebuttal?
Okay, great. Before Mr. Heenan starts, I neglected to introduce an unfamiliar face on the panel. In place of Justice DeWine, we have Judge Wilnowski from the 3rd District Court of Appeals, who is sitting in place of Justice DeWine. Welcome, Judge. Thank you.
Thank you, Chief.
Mr. Heenan.
Morning. May it please the court. As we've said when we started this argument, it's a pretty straightforward case. It's just the interpretation of a statute, and it really, as Justice Fisher pointed out, it really comes down to the placement of a comma. I think the most important comma here looking at this is if you look at the statute between disabled adult and is committed, there's a comma there. When you look at the next part that involves the military service members, it says active duty service member is committed, and there's no comma there, which is showing that the legislature wanted to treat these differently. Looking at it that way, you've got when a series of offenses under 291302, the revised code, is committed by the offender and the offender's same employment capacity or relationship, all those offenses shall be tried as a single offense. The middle part there, where it's or a series of violations or attempts to commit with all these others, those are the parts that give the extra protection to your elderly or disabled adults. You don't get that for just for, in this situation, a bank can't get the benefit of this aggregation for non-complying solicitation, an unauthorized use of vehicle or property, misuse of credit cards, forgery. In fact, the forgery, if you look at the indictment in this case, the only things that were aggregated, because these were banks, were the thefts. The forgeries were not aggregated. I'm not sure if that's what Mr. Pettis is alluding to in his reply brief, that we didn't aggregate everything, because as far as I can tell, we aggregated every theft in this matter under this statute and left the forgeries separate because statutorily we could not aggregate them. If it had been an elderly victim, we could have. Other than that, I mean, looking at his case, Phillips, it does go the other way. There's no question about that, but there's also no question that it's never been relied on for that point of law. Courts that have looked at Phillips have only used it for a juvenile bindover situation. They've never used it for this theft aggregation statute. The Gibson case, that involved an 87-year-old victim, so that doesn't help us here. So that leaves us with the case we have before you, Greer and Williams. So with the Phillips anomaly that no one has ever relied on before or since, all we have are cases saying that the first district was right and that when they read this statute, they read it properly. And really with that, unless the court has any questions, is again, as Justice Fisher says, it really comes down to the placement of a comma and the comma.
Thank you.
Thank you.
Mr. Anselmo, you have saved about 2.5 minutes.
Thank you, Chief Justice. I guess in wrapping this up, I would just again reiterate that, regardless of the application of the precedents, Mr. Pettis has brought to this court 2 specific cases that specifically address this issue, and I've already distinguished why Greer and Williams are not as persuasive authority, and in fact are not helpful and distinguishable. I would also note that in the event this court concludes that this statute is ambiguous because of comma placements, the rule of lenity would apply, and that's what I based on in my supplemental authority. Unlike the federal realm, in Ohio, the rule of lenity is codified under RC 290104A. It's important in statutory construction. And if 2 parties are offering reasonable interpretations, the rule of lenity establishes that the court apply the statute in favor of the defendant. And to repeat, again, we have the situation, we have these 2 districts addressing the issue of the statute in the court. Mr. Pettis, much is being said about the comma placement, but again, Bryant, which I mentioned in my supplemental authority too, says you look at the statute as the entirety, and you can also look at these empowered materia. And as I already indicated, these are, these 2 different types of victims are being separated by a period, and they're repeating basically the similar language of the statutes qualifying the particular victims. And so irregardless of the comma placement, I think a reasonable interpretation is that the legislature, in revising this statute, was essentially applying these particular class of victims and qualifying the particular cases and statutes that would apply based on those qualifications. And with that, I would argue and close that the crux of the statute is not frustrated by Mr. Pettis's interpretation, even construing this as ambiguous or unambiguous. And I would ask this court to accept the proposition of law of Mr. Pettis and to answer the certified question in the negative.
Thank you. Thank you, gentlemen. We will take the matter under advisement, and you'll be notified of our decision.
Thank you.
Thank you, Judge Wilimowski. All right, our second case this morning is 2019-606, the State of Ohio versus Albert Townsen. For the appellant, or excuse me, the cross appellant, Ms. Fry.
Thank you. Good morning, Chief Justice O'Connor, Associate Justices, and may it please the court. My name is Mary Fry, and I'm an assistant prosecuting attorney in Cuyahoga County, and I represent the state of Ohio in this matter. The state is respectfully requesting that this honorable court reverse the 8th District's decision vacating the sexually violent predator specifications attached to Mr. Townsend's 2003 and 2005 offenses because they do not violate the ex post facto clause of the United States Constitution. The amendment to the definition for sexually violent predator did not substantively change the punishment that existed at the time that Mr. Townsend committed the 2003 and 2005 offenses in this matter. What's important for deciding this issue is looking to the legislative history of Revised Code Section 2971.01, subsection H1, which provides the definition for sexually violent predator, and the case law leading up to the amendment for sexually violent predator. The original definition for Revised Code Section 2971.01H1 provided that a sexually violent predator is a person who has been convicted of or pleaded guilty to committing on or after the effective date of this section a sexually violent offense and is likely to engage in the future in one or more sexually violent offenses. After the enactment of this statute in 1997, the Ohio appellate district courts did not have a uniform interpretation of the terms who has been convicted of or pleaded guilty to committing a sexually violent offense. The 5th District and the 3rd District first found that you had to have a prior conviction for a sexually violent offense before being charged with the sexually violent predator specification. The 9th District in State versus Haven found that you did not need to have a prior conviction.
Why does it matter what the appellate court said once this court decided Smith?
I think it's important because the amendment, the 2005 amendment, Your Honor, is a clarification and is based on the lack of uniform interpretation among the appellate courts, and it wasn't in response to this court's decision in State versus Smith.
But it doesn't really matter if it's in response to this court's decision. What matters is the law changed after this court's decision in Smith. That's
right, but Your Honor, it's undecided law. It's an issue of first impression in Ohio, this case, regarding whether an amendment that is clarifying the definition, is clarifying the original definition in a statute.
It's not clarification if it changes the law. I mean, the judiciary says what the law is, not the legislature doesn't get to go back and change that.
But respectfully, Your Honor, the court is able to interpret, but the interpretation is based on what the legislature intended for the terms to mean when they enacted.
Well, I think actually interpretation is based on what the legislation said, and the courts say what the meaning of the law is, and if the legislature chooses to change that, then they've changed it. That's not clarification.
But Your Honor, I believe that court hasn't said that a amendment that is seeking to clarify, and this court has the ability to say that.
Has any court ever said that a change in law after a judicial determination by a court of last resort is not a change in the law? It's just a clarification. Well, where's that?
Your Honor. And that's cited in our reply brief, and that's Binder versus Sunco, which is out of the Connecticut Supreme Court, Your Honor. And it's a civil case that's also then cited in a criminal matter, which is State versus Mark Banks, which came out in 2016 out of the Connecticut Supreme Court. And what it's discussing, and if I quote it, Your Honor, it says, even though the legislative clarification was prompted by a judicial decision that the legislature deemed mistaken, such a clarification does not constitute an invasion of judicial authority. Like legislators, judges are fallible. The legislator has the power to make evident to us that it never intended to provide a litigant with the rights that we had previously interpreted a statute to confer. And it cites to State versus Blasco, which is another Connecticut Supreme Court case. And Your Honor, it continues to go on. Because the legislature has the power to make evident its original intent, its exercise of that power through the enactment of clarifying legislation simply cannot violate the doctrine of separation of powers. So, Your Honor,
you would have to admit that's certainly a minority view, right?
Absolutely, Your Honor. It is a minority view, but this is unsettled law in Ohio. And I think when you're looking at the clarification in this case and the underlying amendment and what the 8th District did with this in terms of an ex post facto clause violation, that this statute, the application of the amendment does not violate the ex post facto clause, because it is a clarification, Your Honor. And also the purpose behind the ex post
Counsel,
Yes, Your Honor.
are you saying that the clarification statute undoes Smith and Smith's application to that case? I mean,
Yes, Your Honor. It provides what the legislature meant for
right, going
Yes, Your Honor.
forward, post Smith.
I think that based on Binder versus Sunco, it means that that's what the intent was always. And there is State versus Johnson, even though there's not an intervening, which we cited to in our brief, which is from, I believe, the 80s out of this court. And it doesn't have an intervening judicial decision, but it stands for the proposition that this court has considered an amendment to a sentencing provision as showing what the law meant at the time that it was enacted. And so I think that is possible for an amendment to provide clarification as to what the statute always was meant to mean.
Well, they can't. So you're saying the clarification, going forward, is going to undo all of the judicial opinions that applied to the first version of the statute. It's going to invalidate all those judicial opinions.
I think it depends on if we're talking about conviction, we're talking about offenses that have already been convicted and are final. I think it depends on where the offenses, when they've been charged and where they fall in terms of the procedural history. And the reason why I bring that up, Your Honor, is because once State versus Smith came out, it's not as if that undid all of the convictions that were previously based on an interpretation that you only needed to have a sexually violent offense charged in the same indictment as the sexually violent predator specification. So I think it involves a timing issue. But I think going forward, if this court says that the amendment provided a clarification of what the legislature always meant, then going forward, yes, any offenses pre the amendment date, which is April 29th, 2005, can be charged and interpreted as requiring only a sexually violent offense within the indictment with the sexually violent predator specification. But I understand that this court is taking pause with this interpretation. And if this court doesn't want to go that route and say that a clarification in this manner would provide the original meaning and explain that the legislature was explaining exactly what it always meant by providing the amendment, the other argument that the state makes, and is a strong one, Your Honors, is that when you're looking at the ex post facto clause, you're determining whether the change in the law increased the punishment at the time that the offenses were committed. And here, the relevant time period, as discussed by this court in State versus Smith when interpreting the language of a prior conviction, it's looking at the charging decision. When, at the time that the person is being indicted, not at the time that they committed their offenses, whether they had a prior conviction. And so ex post facto is dealing with, is there an increase in sentencing? Is there an increased punishment that the person who's committing the offense did not know of? And when Mr. Townsen committed his 2005 offense, he knew that he'd previously committed a 2003 rape, and that if he was charged that day, he could be, and convicted of the 2003 rape, he could be then subject to a sexually violent predator specification for the 2005 offense.
So
And
what is
so
that?
the
So what does that mean? Does that mean that we would reverse one of the convictions and affirm the other, or the specifications?
I think that depends on the interpretation and the argument that this court decides to have as its
say we don't buy your first argument, but we buy at least partly what you just said, that the time he committed these offenses, he could have, that Smith essentially says, Smith only talks about the time of the indictment. So at the time he committed these offenses, depending on the charging order, he presumably could have got the specification for at least one of them. He couldn't really have gotten at both of them, but he could have got the specification for one or the other. So does that mean that we should reverse one of the specifications and the other one's okay?
No, Your Honor. I think that you look at it in the snapshot in time for when each offense was committed. So in 2003, when we're looking at whether the law at the time as it existed at that moment, in 2003, it was unsettled law regarding whether you had to have a prior conviction. And so there isn't a notice issue for the 2003 offense, because in the jurisdiction that Mr. Townsen committed the sexually violent offense, which was the rape in 2003, he could be subject to a sexually violent predator specification.
That doesn't matter, because we say what the law is. So once we've said what the law is, it doesn't matter if those courts had a different interpretation.
I think, Your Honor, that if the court is rejecting my first argument regarding clarification and looking at it at the snapshot in time of when the person was charged, I think, yes, with that argument, you would affirm the 2005 sexually violent predator specification and affirm the vacation of the 2003 sexually violent predator specification and reverse the vacation of the 2005 sexually violent predator specification.
Okay, thanks.
If there are no further questions, I'd like to reserve the rest of my time for rebuttal. Thank you.
All right, Mr. Clark.
Chief Justice O'Connor, may it please the court. Before April 29, 2005, a sexually violent predator specification could only attach to the indictment of somebody who had a prior conviction. After April 29, 2005, House Bill 473 changed that. A sexually violent predator specification could attach without a prior conviction. This amendment to the law changed the evidentiary burden the state faced to prevail on a sexually violent predator specification. For people facing a specification without any prior sexually violent convictions at the time of indictment, the newly amended statute authorized a more severe punishment. This was not a clarification of the law, it changed how the law operates, and applying it retroactively to conduct that occurred before its effective date violates the ex post facto clause of the United States Constitution and the retroactivity clause of the Ohio Constitution. The state's position that the 125th General Assembly merely clarified the intention of the 121st General Assembly is untenable. Clarification or interpretation of a statute is an inherently judicial function. Conversely, prospectively making the law is a legislative function. Even Western Security, which is a California case relied upon heavily by the state, makes this distinction, saying, and I'm quoting the opinion, a legislative declaration of an existing statute's meaning is neither binding nor conclusive on construing the statute. Ultimately, the interpretation of a statute is an exercise in the judicial power the Constitution assigns to courts. This logic holds here. For one reason, 209 members of the 121st General Assembly were gone by the time that the 125th General Assembly was seated. But more fundamentally, there was nothing to clarify. This court interpreted the prior revised code 2971.03 conclusively in State versus Smith. And when this court interprets a statute, it uses tools of construction to tell us what the statute has always meant.
Mr. Clark, I'm sorry, you don't have to convince me at least that the clarification argument that the state makes isn't persuasive, but I am concerned about or interested in the other kind of argument that they've kind of made, I guess, obliquely in their briefs and today, is that when he, at least at the time that he committed the second offense, he could have, based on Smith, received a sexually violent predator specification for that, depending on the timing of depending on the timing in which the state would charge him for that offense and the other offense. So, if you, I think we've been working under the provision of the ex post facto law that talks about an increase of a punishment from the time the offender committed the offense. Theoretically, he could have had the same punishment, at least for the second offense. Can you address that?
Yes. First, I think it was raised in the first instance in the reply brief, so it's waived to a certain degree. But also, the ex post facto clause prohibits ex post facto application of 4 categories of law, and that's from Calder versus Bull in 1798, a Supreme Court case. And the state's argument, if it persuades this court that punishment wasn't increased, which is Calder's 3rd category, still fundamentally changes the burden of proof necessary to increase the punishment. Because prior to April 29th, 2005, a prior conviction was a necessary element to prove a sexually violent predator specification. After April 29th, 2005, that specification could be proven looking just back to conduct that was never indicted.
And I've struggled with that. Does the ex post facto, I mean, it applies to offenses. You can't increase the elements, change the elements of an offense. But is a specification is an offense, or is it just something that's, I mean, here it seems the offenses are the rapes. This is really, isn't this just something that enhances the punishment? And does the ex post facto clause apply to that? And if so, give me some authority for that, if you can.
So this is a tough situation because the ground is shifting underneath the argument a little bit because of arguments made for the first time in the state's reply brief.
I understand.
But Apprendi would tell us something about this because the sexually violent predator specification needs to be proven beyond a reasonable doubt. There are elements to the specification. You need to prove a risk of reoffense beyond a reasonable doubt. And that is what authorizes a punishment increase from a maximum of, it was 10 years at the time of the offense. It's 11 years now for a first-degree felony. From a determinate 11 years to an indeterminate life sentence. So the ex post facto clause and the 4th category of Calder versus Bull applies directly to this circumstance because I think in 2000, the Supreme Court of the United States decided Canales versus Texas, which said if you change the evidentiary burden in a way that lessens the state's burden of proof, change rules of evidence that change the state's burden of proof, that is an ex post facto clause.
But does that apply just to an offense, or does that apply to a punishment, though? I mean, it's not really changing the state's burden of proof for the offense here. I think that's what I'm struggling with.
The punishment, respectfully, the sexually violent predator specification needs to be proven prior to sentencing. There's a separate trial at which the elements need to be proven to a jury beyond a reasonable doubt. So it is an element. And it's an element that allows for a dramatically increased punishment. So I think that the 4th category of Calder versus Bull is squarely on point here. And the state's argument that nothing changed from an ex post facto analysis should be denied for that reason alone. I know that there's the beginning of the state's argument focused largely on clarification versus amendment. I want to point to one more piece of authority that I think squarely demonstrates why this is an amendment and not a clarification, and that is the Supreme Court of the United States decision yesterday in Bostick. And what the court said in Bostick is that when faced with a dispute between the text of a statute and the extra textual evidence of legislative intent, the written word is the law, and all people are entitled to its benefit. To hold otherwise would deny the people to continue relying on the original meaning of the law that they have counted on to settle their rights and obligations. So we have authority from the Supreme Court of the United States that shows exactly why the legislator was certainly within its rights to amend the statute moving forward to make the sexually violent predator specification easier to prove. But they are not able to retroactively apply that. And what the new revised code 2971.03 does is it makes it easier for the state to prove necessary elements to enhance punishment from a determinate period of 11 years to an indeterminate life sentence. If there are no further questions, I ask this court to affirm the 8th District and to vacate Mr. Townsend's sexually violent predator specification and remand for resentencing.
Thank you. Ms. Fry.
Thank you, Your Honor.
Can you address the waiver issue?
Yes, Your Honor. So I think it's important to look at the briefing that occurred at the 8th District. Mr. Townsend's counsel at the 8th District had an assignment of error that said the sexually violent predator specifications attached to the 2003 and 2005 offenses must be vacated. And that was based on State versus Smith and didn't address an ex post facto issue. The state responded with saying, based on another case that's been held for this decision, State versus Ryerson, the 8th District had provided the ex post facto argument and explaining that it was a violation with the amendment. And so the state addressed that in the briefing and said that it didn't violate ex post facto, provided the clarification argument, and also made the argument that based on the charging, that it's the timing of the charging, and that Mr. Townsend would still be subject to a sexually violent predator specification because he's not a first-time offender. I don't think that in our appellee brief at the 8th District, we laid out the argument as much as we did in our reply brief here, but I do think that this issue is not waived, especially.
But what did you raise it in your principal brief here?
No, Your Honor.
Well, I mean, how is the defense able to have a chance to respond to that then?
I think that our argument regarding the timing of the amendment comes into play in response to Mr. Clark's argument in his brief relating to the separation of powers and the notice requirement of the ex post facto clause, Your Honor. And with the 1 minute 1 minute and 40 seconds that I have left, Your Honors, I would just like to address Mr. Clark's argument that the sexually violent predator definition and proving that there's a prior conviction is an element. In this court's decision in State versus Hand, it's talking about a sentencing enhancement. And then I can't remember, Your Honors, respectfully, the decision that came out dealing with a prior juvenile adjudication as an element of an offense. But this court said in that decision that the prior juvenile adjudication was dealing with an element of the offense and not a sentencing enhancement. And the only reason why I bring up those two cases to explain and distinguish an element of an underlying offense versus a sentencing enhancement that doesn't come into play until the person has been convicted of the underlying offense. Contrary to Mr. Clark's argument, the ex post facto law clause does not involve changing the burden of proof. Here at issue is whether there's been an increase in punishment based on the new law as opposed to what the punishment could be at the time of the offense. As Justice DeWine pointed out, when focusing on the 2005 offense, it was possible if the state had charged Mr. Townsen at that time with the 2003 offense, when he committed that 2005 offense, he could have had a sexually violent predator specification attached to the 2000 rape. So it's not that in all cases here for the prior offenses that he would not have been subject to a sexually violent predator specification. He could have. It's on a timing decision relating to charging. So therefore, there's no increase in punishment. The state would therefore respectfully request that this court reverse the 8th District decision. Thank you.
Thank you. We'll take the matter under advisement and you'll be notified of our decision. All right, we're here on case 2019-729 and 19-822, the state of Ohio versus Mark Price. For the appellant, Ms. Moran.
May it please the court, Susan Moran here on behalf of the appellant Mark Price. I'm here also with my amicus, Mr. Robert McCaleb. We'll be taking 10 minutes and Mr. McCaleb will take a 5-minute rebuttal. In defining causation, a trial court must ensure that the jury understands that the defendant does not cause serious physical harm when the defendant's actions merely contribute to the victim's injury, but were neither independently sufficient nor necessary for the serious physical harm to have occurred. In cases where there are multiple sources of potential injury, as in this case, merely reciting the general causation instruction is inadequate and thus incorrect. A trial court that refuses to give or even consider an instruction on this concept when requested to do so abuses its discretion. In this case, the instructions were inadequate because they failed to address the important concept of distinguishing between actions that were merely contribute to serious physical harm on one hand, which is not sufficient causation.
How does an instruction on but-for causation not make that distinction? I mean, that's...
So I think that Barrage is incredibly insightful for us.
Right, and Barrage says that an instruction on but-for causation is enough.
Well, and so really the plain meaning, according to Justice Scalia, is really what's at central issue here. And what happened in Barrage is Justice Scalia applied the rule of lenity. And as this court knows, the rule of lenity is the application of the common understanding of but-for. And so what we're seeking here is simply a clarification of what is criminal culpability when but-for causation is at play. And I think it's undisputed that but-for causation is the rule of law in Ohio. And we know that because we look to the jury instructions, and specifically, as we know under the Ohio jury instruction, causation instruction. In that instruction, it says conduct that is the cause of a result if it is an event but for which the result in question would not have occurred. What we're seeking here is a clarification, and what we need is the additional definition to a lay jury. In cases such as this, where there are multiple potential causes of injury, a jury must discern the level of culpability of the accused. And we do that so that someone is not wrongly convicted. What we must hold is an individual responsible for what they actually did. So what we're looking for is something like this. This would be included. But for is defined as meaning that you must find that the conduct of the defendant was either independently sufficient to cause the serious physical harm or was necessary for the serious physical harm to have occurred, regardless of the contributing actions of others. So what we're looking for is a layman's explanation of what does but for mean. It is so essential in cases where, unfortunately, due to the opioid crisis, individuals are dying with multiple drugs in their system. And as a result, we have multiple contributors to those drugs. And what we want to ensure is that individual who gave that poison is the one that is convicted for murder. Not merely...
Counsel, what level of evidence would have to be presented? Just the compilation of drugs in the the body, or the toxicology of the victim, in order to get that kind of a definition, that kind of clarification?
Certainly. So what we would need is the testimony of the expert, likely the coroner. And what we would need the coroner to say is what specific drug was independently sufficient or necessary to have caused that death. And that's exactly what happened in Barrage. In Barrage, there were multiple drugs, and the testimony was that a certain drug did not cause the death, and the other one did. So what we need is a definition. Is this fentanyl independently sufficient to have caused the death?
And so you're questioning whether the, what was it, heroin laced with fentanyl?
It was, Your Honor.
Whether that was sufficient to have caused the death?
Right. So in our case, there are multiple possibilities for the cause of death. We had an individual with cardiomyopathy, with decreased lung function. We had some information, some evidence submitted that perhaps he committed suicide by purposefully ingesting drugs that may not even have been furnished by my client. So what we need is a toolkit for this jury to draw upon to discern all these possible contributing causes. So we need testimony. And in this case, quite frankly, we didn't even have testimony from the coroner. So we can't even simply look back in the record because it wasn't asked specifically, was it independently sufficient to have caused or necessary to cause the death?
But none of those evidentiary issues are in front of us, are they?
No, what we have in front of us is a lack of jury instruction.
But again, I can't, it's hard for me to get over the fact that the judge gave an instruction on but-for causation. The judge gave an instruction that complied with Breeze, which is what you're asking for. So I'm a little lost.
So I think it's wonderful that we have the United States Supreme Court with an issue almost analogous to the one.
Right, and the United States Supreme Court said the instruction that the judge gave in this case was okay.
Well,
this falls right in there.
So here's the problem. It's insufficient. And what Justice Scalia said is we need, under the rule of lenity, to give but for the layman's understanding of but for. That way the jury can look at what it's supposed to do. What tools do we give this jury? And we simply didn't give the jury that ability to discern when there are multiple causes, what is independently sufficient or necessary.
Wait a second. Why is independently sufficient or necessary? That's not the law. That's not what Breeze says. It says that where Breeze says is where there's not but for causation, it has to be independently sufficient or necessary. Here the jury found but for causation.
I'm saying that they did not find but for because they were not given the particulars of what but for means because of the legalese of the other.
So what should the judge have said?
So I think first what should have happened is the causation instruction should have been read. And then in addition to that, the court should have gone further to define what but for means. And but for means that you must find that the conduct of the defendant was either independently sufficient to cause.
That's not what but for means though. If it's independently sufficient, that is for a situation when you don't have but for causation. I think you're confused on the law here.
Well, I respectfully find
so independently sufficient is a situation where no one's but for. You may have three people who cause a harm, which each one of them would be independently sufficient to cause a harm, but no one of them is but for causation. That's where that instruction comes in.
I believe that everything requires the initial but for, and then we go beyond that to proximate cause, if that's what you're alluding to. I'm alluding to
independently sufficient.
Independently sufficient, according to Justice Scalia in Barrage, is the definition of independently sufficient is the definition of but for.
No, it's not. I'm sorry, but you're horribly confused on this. I mean, it's.
All right, counsel, let me ask you a question. Given the evidence that was before the jury, which there was excluded medical records, evidence that the victim had, intended to buy drugs sufficient to kill himself, all this information was not before the jury, correct?
Correct.
And what was before the jury was that this victim consumed heroin laced with fentanyl that was supplied by your client.
Correct.
Okay, so given those facts, how can you require a court to give an instruction that would be based on other potential causes of death that were not before the jury?
Well, Your Honor, we did have testimony from the coroner that the decedent had a very sick heart and very sick lungs. And our expert, the defense expert, said it was his belief that the decedent did not die from the fentanyl, but in fact died from his heart and lung conditions. So there were two competing potential causes of death that were submitted to the jury.
And so you're saying natural causes versus heroin laced with fentanyl was the choice the jury had to go with?
Correct.
And they found the fentanyl.
Well, quite frankly, they found him not guilty of involuntary manslaughter, but guilty of corrupting another with drugs. So it was very convoluted in the way that the instructions were read to the jury. So I think inherently, I think it's difficult for a jury to find a drug dealer guilty of involuntary manslaughter simply by giving somebody else drugs. I think we're seeing this in Cuyahoga County. We're not seeing a lot of convictions for that act of involuntary manslaughter. I think what went wrong here is in between the definitions of causation, there were about 5 other pages of instructions, and then a mild reference to causation with regard to the instruction on corrupting another with drugs. And the court said the same causation instruction applies. And what is difficult here is not a failure to concentrate on what the jury had to really look for causation. For what was before them? What did they have to discern to determine causation? And we're saying the but for was not clarified. It didn't emphasize enough that the jury had to go through this very complex legal analysis to determine culpability.
All right, counsel, you're into your co-counsel's rebuttal time. You can keep going, but if you want to save something for him.
I'll give the balance of time, Mr. McCaleb.
All right, thank you. We'll start with Mr. Mullen for the appellee.
Good morning, thank you.
Mullen, I'm sorry.
That's okay.
Catherine.
Good morning, Chief Justice, Justices, may it please the court. Catherine Mullen on behalf of the state of Ohio, appellee in this case. We are asking this court to either dismiss this appeal or affirm the decision of the 8th District. And there are at least 3 reasons for this request. First, there's no real conflict between the 8th District's decision in Price and the 5th District's decision in State versus Costo. This case initially came to this court as a certified conflict, which the 8th District had sua sponte entered, and then also through the 3rd proposition of law from Mr. Price in the jurisdictional appeal. We don't believe that there is a conflict, as Costo involved a sufficiency review, and the 5th District specifically did not reach the question of whether and what jury instruction would be required. Further, as will be explained, the facts of this case are readily distinguishable, where it is clear from the testimony in this case that the fentanyl sold by Price is what caused Mr. Dawson's death. Second, Mr. Price did not request the jury instruction that he is now asking this court to adopt. Mr. Price's trial counsel, if you look at page 1074, I believe of the transcript, Mr. Price's trial counsel used the verbatim holding of Barrage in their request for a jury instruction. They did not ask for further clarification of Barrage or some kind of adaptation of Barrage. They asked for Barrage itself. That was also the issue that went to the 8th District Court of Appeals. Now before this court, Mr. Price is asking for something that Barrage never did, which is to argue that the state must prove that the drugs sold by Price were both independently sufficient to cause the victim's death and that the drugs were the but-for cause of the victim's death. Because he did not preserve that argument below, it is waived for all but plain error, so this case would be a poor vehicle to decide that issue. Third, the lower court, the 8th District, got it right on both the facts and the law. The 8th District largely adopted the analysis from State versus Carpenter from the 3rd District, which found that Barrage does not require a deviation from Ohio's general jury instructions on causation. And the 8th District went further and found that even though the trial court denied Price's request for a Barrage instruction, the trial court did essentially give the instruction that Price had requested. So even if this court were to find that barrage is a correct statement of Ohio law, this case would not require reversal because that instruction was what was given to the jury. Turning then to State versus Costo, Costo has a lot more factually similar with barrage than what we have here. In Costo, the victim, his toxicology report showed that he had heroin, cocaine, and some marijuana in his system when he died. The medical examiner in Costo's case, quote, could not opine on cross-examination that the victim would have died from the heroin use in and of itself. Contrary to what my friend on the other side told you a couple minutes ago, that is not the testimony that we have here. If this court looks at pages starting at 509 and going through at least pages 512, it is very clear from the testimony of the medical examiner, Dr. Philo, that the antidepressants that he wrote along with the cause of death played very little role, and that if the antidepressants themselves had in fact not been found in the toxicology, Dr. Philo would have written the cause of death as acute intoxication as a result of fentanyl. He clearly states in the testimony that the fentanyl is the primary cause and was in and of itself capable of causing Mr. Dawson's death.
Well, counsel, was there testimony that the weak heart and I think maybe lungs was the other, was a trigger here? This is what caused his death? Independent of the drug consumption?
I think Dr. Philo testified that the cardiomyopathy and the physical abnormalities observed during Mr. Dawson's autopsy, he would have ruled that to be a natural death had it not been for the toxicology report. He did say that the findings of the heart and the lungs would have made it so that he could have ruled that the victim could have died from that alone had it not been for the toxicology report. But we are left then with the toxicology report and with the cause of death, which states that it was due to fentanyl in combination with the prescribed antipsychotic medication, which Dr. Philo testified that the prescribed antipsychotic medication was within the therapeutic limits for what he would have expected to see based on Mr. Dawson's prescriptions. He's also testified that the heroin and the fentanyl were lethal. Right, so he testified that the fentanyl is the cause of death, and heroin was noted. Heroin metabolizes almost immediately upon entering the body, but the metabolites of heroin, which are codeine and morphine, were only found present in the victim's urine, meaning that it had been some period of time for the metabolization of the heroin. And Dr. Philo testified that that could have been anywhere from a period of multiple minutes to a period of hours. And part of the reason that we see that in these type of cases, particularly as heroin and fentanyl mixes, is another thing that Dr. Philo actually testified to, because Mark Price is not, to my knowledge, he is not a chemist and he is not a pharmacist, and he's not making a pill with concentration, uniformly throughout it. So what we can see is that maybe Mr. Price took an initial hit of heroin, but then the next hit he took was more fentanyl. It's not uncommon in these powder-based cases, which is what this is, to have a lack of uniformity in the substance itself. Which again, this goes back to the testimony of Dr. Philo, and that would be, I believe, page 522 of the transcript. Dr. Philo did also testify about this idea of post-mortem redistribution, which was something that the defense expert talked about.
Do we have an assignment of error on sufficiency of evidence?
No, we don't, Your Honor. And I don't think it's necessary to get into some of this, but they have raised a lot of it in response to the jury instruction issue, although it's more appropriately considered in a sufficiency or manifest challenge.
Yeah, I'm pretty sure we're not going to decide sufficiency in this case.
Thank you, Your Honor. Then moving on to that, the next question, I guess, would be whether Costo got it wrong, whether the certified conflict case got it wrong. Barrage, as the 8th District noted, barrage is not controlling authority. It was a U.S. Supreme Court decision reviewing a federal statute, so it's merely persuasive to this court. This court in State versus Phillips has recognized limitations in the but-for test. There are multiple cases that both my amicus and I have cited in our briefs for other examples of where but-for limitations have been seen. So to the extent that Mr. Price's argument is seen as preserved for this court at all, I do believe that it would be inappropriate to adopt their proposed jury instruction, which would eliminate the contribution rule modification to a but-for test. Finally, again, and this going back to the facts briefly, the 8th District found that the trial court gave the instruction, essentially that gave the instruction that Mr. Price requested. The 8th District the trial court told the jury that they had to apply but-for causation. That's what barrage requires. The 8th District opinion, the trial court also gave the limiting instruction for legal cause, for proximate cause. Whether or not proximate cause is even required in these situations is a different matter, but regardless, we had that there. And what the trial court did not instruct the jury on, which is what Mr. Price focuses on, is this contributory cause issue. I think it's an interesting issue, but this is not the case that this court needs to decide that in, because that's not what the jury was instructed on. They were instructed on but-for causation. And with that, I will cede the rest of my time to my amicus counsel. Thank you, Your Honors.
Ms. Braun?
Thank you. Chief Justice, may it please the court. Price first embraced barrage, but now he wants to run from it and to require a causation plus instruction that's not rooted in the barrage case. He got the substance of the instruction he wanted, now he's moving the ball. Although today we heard from his counsel that the OJI instruction that he in fact received is correct. Now the request is that it should have been repeated, or something further should have been repeated later in the instruction, but it seems to me it's significant that they're saying that the OJI instruction is a correct statement of Ohio law. We wholeheartedly agree. He's shown no reason for this court to reverse the judgment of the 8th District, so we would request affirmance. The point of barrage is that but-for causation is sufficient for a criminal case. You don't have to also show independent sufficiency. That, however, is what Mr. Price is asking for here. He's asking for both, but again, that is not rooted in barrage. Ohio law is perfectly in line with the barrage case, although it's not controlling, to be sure. It's Price that wants to do something strange with that case by requiring both independent sufficiency and but-for causation. The Ohio jury instruction that was given in this case simply reflects Ohio law regarding causation. It's a mistake to assume that there can be only one actual cause of an event. Ohio law, as well as barrage, recognizes that there can be multiple actual causes of an event. The defendant's action, in fact, can be the straw that broke the camel's back and still count as a but-for cause. And we can look at cases such as the Phillips case, which is in our brief, and my co-counsel cited to a minute ago, the Hall case, the Wilson case. These are all examples of Ohio cases that involve multiple causes, but the fact that there were multiple causes did not absolve the defendant of liability. What Price asks for here would fundamentally change the Ohio law of causation and potentially impacting criminal trials and drug dealing cases, as we're in the middle of the opiate crisis, and in other cases throughout the state. He wants a sweeping instruction, a sort of meta law of causation. It would create confusion for the trial courts in instructing juries and potentially impact other criminal trials in creating reversible error in instructing juries on causation. Price in his amicus's brief suggests causation instructions should be longer, more detailed, include hypotheticals as a matter of law, apparently. But Ohio jurors are smart enough to understand the straightforward language of the Ohio jury instructions we have on causation. There's no need to change them. in fact, requiring more convoluted instructions as Price asked for is more likely to confuse a jury. As my co-counsel stated, we don't believe that this case presents the factual scenario for this court to decide the extent of a contributing cause as a rationale or causation in Ohio law. Unlike the Costo case, which Ms. Mullen discussed a few minutes ago, the facts here were pretty clear in the sense that you have the medical testimony of the deputy chief medical examiner saying that it was the fentanyl was the primary cause of death and that Mr. Dawson would not have died but for the fentanyl, or that was the primary cause of death. And that's in pages, I believe, 502, 512 of the transcript. So this is a textbook case but for causation being shown on the facts. The instruction that was given, as has been noted several times during this argument, actually expressed that concept, expressed it clearly. And so therefore, we would respectfully suggest that only deciding what is before you on these facts, and there's no need to go into the global philosophical causation questions that Mr. Price and his amicus urge you to get into today. And if the court has no further questions, we would ask that the judgment of the 8th District be affirmed. Thank you very much.
Thank you. Mr. McCallum.
Good morning, Your Honors. May it please the court. My name is Robert McCaleb. I'm here on behalf of the Cuyahoga County Public Defender's Office in support of Mr. Price. I have a few brief points of rebuttal. The problem with these instructions is that they are so inadequate as to be incorrect for this case.
Counsel, let me ask about that. I heard your co-counsel kind of intimate that the jury instruction given was the state of the law in the state of Ohio, correct?
Yes, that is what she intimated.
Well, then, and aren't we looking by the trial court at an abuse of discretion standard?
Yes, and
well, then
so
if it's the state of the law and that's what the trial court gave, how is that an abuse of discretion?
Well, so these instructions are essentially identical to the OJI instructions. Those instructions have not changed materially since at least 1992. And that is, of course, before the opioid epidemic. That was a time when mixed drug fatal overdoses were comparatively rare, and especially compared to much more causally sort of straightforward criminal acts like stabbings or shootings. And so these instructions, they might very well, I have some other problems with them, but they very well may adequately prepare a jury to decide causation in a simple case, a gunshot murder. But in a case like this, where there are multiple causes or potential causes of varying degrees and strength, it's not sufficient to simply say, well, listen, here's the baseline instructions. We're not going to add anything onto that. I mean, the criminal rules in Ohio contemplate case-by-case instructing. And I think that's where the abuse of discretion is here, where Mr. Price's trial counsel indicated to the judge, you know, he essentially said, I am not convinced that the proposed jury instructions on causation are sufficient to explain to the jury what its job is in this case. And at that point, for the judge, who, by the way, indicates in the transcript that he would read barrage after he had already made his ruling. So he hasn't actually read the case, at least recently. You know, he's not reading it contemporaneously with his decision on the instruction. And so for a court to just say, I understand there are concerns from the defendant about the adequacy of these instructions, but I'm not going to exercise my discretion to do case-by-case instructing, despite the fact that additional instructions in this case would make these fairly difficult concepts significantly more understandable for lay jurors. You know, all of us are trained.
Did trial counsel submit requested jury instructions?
Yes, Your Honor. And those are, I see my time is almost up. If I could just answer your question.
Answer.
Thank you. Those instructions were, as opposing counsel said, very similar to barrage. But the significant
with trial counsel's submission of they weren't adequate, any more adequate than the OJI, in your opinion?
I am concerned that they would not be any more adequate than the OJI. But what I'm glad about trial counsel doing, and what I think really is the key issue, is that trial counsel indicated to the trial court, I don't think that these instructions are sufficient. The trial court essentially said, "No, too bad," and that was the end of it. And I think in a case like this, where causation really is difficult, I mean, I think we can all agree on that. To just leave in the lay people, jurors' hands, instructions more fit for a slip and fall case, I think that was an abuse of discretion.
Thank you.
Thank you.
Thank you. We will take the matter under advisement. You'll be notified of our decision. All right, our next case, our last case today is 2019-897, 2019-1128, the State of Ohio versus Lamont Rue. For the appellant, is it Ms. Music?
Yes, Your Honor. Good morning, Chief Justice O'Connor, fellow justices, Attorney Partlow. May it please the court. I am Ashley Music, Trumbull County Assistant Prosecutor, and I represent the state of Ohio in this matter. The state would like to reserve 3 minutes for rebuttal and note that we will be sharing our time with the Ohio Attorney General's office. The question before the court this morning is whether a trial court retains jurisdiction due to tolling to revoke community control sanctions when revocation proceedings are initiated after the initial specified term expires. The state submits that a trial court does retain jurisdiction unless the 11th District Court of Appeals erred when it concluded otherwise, and we're asking this court to reverse that decision. It is well-established Ohio authority that a trial court retains jurisdiction for the duration of community control, which can be extended and subject to that 5-year limitation. A jurisdiction is a question of law, and that's reviewed de novo. And the jurisdiction claim was originally raised by the defendant appellee in the trial court. The Court of Common Pleas has original jurisdiction in all justiciable matters, and in other words, the trial court would be divested of that jurisdiction and able to initiate or revoke community control when the term expires. However, 2 exceptions are contained in the Ohio Revised Code. Those are found in Revised Code Section 2929.15 and reiterated in 2951.07. Those 2 exceptions extend the duration of community control, and they necessarily operate as an extension of time beyond the initially stated term. Again, subject to that 5-year maximum.
Counsel, wasn't the basis for the extension of the community control, or the jurisdiction, I should say, is a mistaken belief that restitution would allow for it by the trial court?
So, Your Honor, if we're talking about the second revocation proceedings, the discussion between defense counsel who raised the jurisdiction and the trial court was that community control sanctions were continued due to multiple violations, including the failure to pay restitution. And certainly we would note that that would be subject to that maximum 5-year duration. The trial court's jurisdiction could not extend past that point. However, in this case with tolling, that time period is paused and it's necessarily extended.
Here the trial court never found that the statute was told. We don't really know, assuming we think it is told. I guess we have the probation office report, but there's really no evidence there's no finding about tolling. Would we need to remand this to the trial court if we agree with you to say, okay, was it told during this time period? What time period did he abscond?
Okay, Your Honor. So I think answering your question is going to be two-part. One, while we were at the 11th District, we indicated that they could remand to the trial court for the trial court to expressly find it had jurisdiction based upon tolling. However, the trial court did find it had jurisdiction, granted for the wrong reason. However, it reached the correct result, and that being that there was a tolling period. However, we have in this case a defendant who pled guilty to one probation violation, which included his failure to report for a period of time. So this court does have a record where it would support tolling at least from November the 3rd of 2016 to April 20th of 2017, when he was brought before the court for disposition. As to the second period of time, the defendant in this case pled no contest. There was no contention that he did not report to his probation officer. There was no discussion. So based upon the record in this case, the court could just affirm the trial court's decision and reverse the 11th District. A remand would not be necessary. However, the court could remand for the trial court to explore the tolling like the Meyer court had an opportunity to do. But instead, the 11th stripped the trial court from that possibility altogether. Speaking of Meyer, they did have discussions about tolling, but it's very similar to the case we have at hand in the fact that tolling doesn't necessarily become relevant until a trial court attempts to revoke outside that initially stated term. And that makes sense. And that's because these two tolling events have to operate as a pause, because you would be rewarding a wrongdoer for their wrong by not operating as such.
So how does someone who's on community control, say they had a period where they didn't report, say that it was told during that period, how do they know if they're still on community control? How do they know when it ends?
Well, Your Honor.
I mean, can't this just be a gotcha? Okay, well, yeah, I thought my community control was done, but oh, by the way, you skipped town for 6 months, and so it was really extended.
Certainly, Your Honor, and I think that's why we have the statute for tolling, specifically because if a defendant is willfully evading the court supervision, he's clearly not serving that term of community control. That's why this operates as an automatic tolling, whereas a violation is a positive drug test or not gaining or not.
Right, but how does someone know their community control has been extended because of tolling?
Well, they wouldn't until revocation proceedings would be initiated. However, the defendant is on notice about the terms and conditions of his community control. And by failing to report, he is on notice that he is in trouble, for lack of better words.
But how does he know the consequences of tolling and thereby an extension? He doesn't report for a month. Okay. Does that automatically toll and then extend his community control for a month?
The state would submit absolutely it would, but it would only become an issue if the court was attempting to revoke outside that initial time frame.
Counsel, doesn't a determination that it was a willful non-appearance have to be made in order to find a violation? It doesn't automatically. I mean, someone may have had a defense to why they didn't report, and that wouldn't be a willful absconding. So doesn't that have to be made first before community control expires?
Absolutely, Your Honor. And generally speaking, that would be taken care of during the revocation proceedings if a defendant were to admit guilt to the violations, which would include failure to appear and report to your probation officer. Absolutely, that would equate to a willful absconding in this matter. And that's how this court has defined absconding.
What triggers the tolling? Is it when the probation officer reports that he didn't report, or is it when the court issues a capias? What's the triggering event where you calculate the tolling?
That's a great question, Your Honor. And it's the state's position that based upon the plain reading of the statute, the triggering mechanism is actually the defendant's action. It's upon absconding or upon confinement in an institution that triggers the toll. It is not the capias being issued by a trial court. In fact, the statute is silent on any state-initiated action.
Okay. Say we have a defendant who's on community control for 3 years. The first year he's supposed to report every week. He misses 10 weeks here and there, not all together, but a couple in January, 3 in February, maybe a few in July. Then the second year he misses another 15 weeks, again, all spread out. And the third year he doesn't miss any. So is his community control extended 25 weeks?
The state's position would be yes. The trial court could make that argument that it would be extended for the 25 weeks.
Okay, and so how does the defendant know that?
It would only become relevant if he.
Well, no, it would be relevant. Say the defendant stole something from Walmart. He's not allowed to go into Walmart stores. He needs to know whether his community control is up or not, right?
Absolutely, Your Honor. And in this case, the automatic tolling does automatically extend that 5-year duration that the trial court would have jurisdiction. Now, the defendant is
okay, so even if he misses just 1 week, it's extended by 1 week?
Not necessarily. It would depend on the facts of the case. Could you argue that? Absolutely, Your Honor.
But doesn't he need to know before he violates his community control whether he's on it? I mean, you said it depends on the facts of the case. I mean, how does someone know if their community control has been extended for 3 weeks because they missed 3 weeks of reporting?
Your Honor, that is a good question. And in this case, I think that example of 3 weeks is probably unlikely to occur and would unlikely become an issue.
So counsel, under Justice DeWine's scenario where we've got 25 weeks of missed reporting out of 3 years of the requirement, you're saying that one defendant could be then have his or her community control extended by 25 weeks, and somebody else couldn't at all, even though they're equally triggered automatically. So, and say that they were both willful. One gets the benefit of not having an extended reporting period or community control, and the other has the burden of an extended community control, and that's all based on what? Whether your probation officer likes you?
No, I don't think that's necessarily true. So we know by the statute that the trial court has discretion to perhaps terminate early. They can terminate probation.
Wait a minute. How would the trial court know? You're reporting to the probation officer.
Yes.
So if the probation, you've got 25 weeks of missing in one case, and the probation officer doesn't violate you. You've got 25 weeks in another case, and for whatever reason, the probation officer does file a violation with the court. So that's not judicial discretion at this point, because the first case is never before the court to exercise discretion. How is that an equal application here?
You're saying that one person would be extended by the probation officer. Is that what we're?
No, there would have to be a violation and gone back to court. But you're saying in both cases, it automatically is triggered, and that person is eligible for 25 more weeks of reporting.
Yes. And again, Your Honor, I think the way that this would operate is if, for instance, during that period of time, the defendant was revoked. And it would be in that questionable period of time, because we would never have to address that if in the initial 5-year period it was revoked then. It would never even have to be addressed. So I think the number of cases that would be affected would be minimum. And I do know that we have agreed to share some time, and I would like to give counsel for the Ohio Attorney General's office an opportunity to speak.
All right. Mr. Hirji?
Thank you, Your Honors. Shams Hirji on behalf of the Attorney General's Office and in support of the state. Text, statutory context, and precedent all clearly show why the 11th District was incorrect when it concluded that the trial court here lacked jurisdiction, even though the trial court initiated community control revocation proceedings before Rue's tolling adjusted community control period came to an end. By its plain terms, the tolling statute at issue here provides that the tolling period starts once the offender absconds. It nowhere suggests that the state or the trial court must take some further action.
So how does the offender know that his community control has been extended?
Your Honor, the defendant is presumed to know what the law means, just like we all are.
I'm not sure I know what the law means. If he doesn't show up one time, is he absconded?
There will be a hearing, right? And if it's determined.
Well, no, apparently, well, there might be a hearing at the end, but he won't have that hearing before his community control has been extended.
You're correct, Your Honor. Just like a person who, say, is subject to a statute of limitations, for example, the one in State versus Best, where you guys interpreted, what does it mean when the statute says that the period of limitation shall not.
Okay, so if he misses one hearing, is he one meeting? Is he absconded?
Your Honor, it will be a factual determination. Again, I don't.
Okay, well, that's the facts. He didn't show up 1 week. Does that meet the legal requirement for absconding?
I'm not sure that those are the facts here, but.
Well, those are the facts in my hypothetical. He missed one meeting. Is that absconding?
If it was a willful failure to appear, that yes would meet the definition of absconding. That this.
So every probationer out there who's missed a probation, meet with their probation officer, has now had their community control extended?
Your Honor, they have, but again, it possibly, but it would require a willful failure, and then it would require, of course, to determine was that intentional. Then you would have to have a subsequent prosecution. There would need to be potentially a judicial fact-finding mechanism. So
you would agree that it's kind of a shotgun approach by the probation officer on whether or not they're going to bring to the attention of the court that the offender failed to report one or more times?
I don't think it's a shotgun. I don't think it's.
Well, what are the guidelines that would dictate it being brought to the for the hearings and everything else you mentioned have to happen?
Your Honor, if the probation officer actually thought that there was a violation, then I think that the probation officer would bring that charge.
I thought you said there's an automatic violation by not reporting.
There certainly is. Well, there certainly is, but of course there has to be a violation. I understood your question to be, if there was a violation, how do we know that the probation officer would bring that to the court's attention?
Well, we know that you're saying that it's an automatic violation, right? Both you and your co-counsel, automatic violation.
Yes.
So what's the standard to bring that to the trial court so we have some, certainty in what the defendant can expect?
Your Honor, the standard is whether there was a willful failure to appear. That's a quite high standard, I'll just say. I mean, they have to appear, they have to fail to appear, and it has to be willful. Will there be fact questions at the margin of whether, in fact, there was a willful failure? Sure. And at that point, the probation officer will make an initial determination as to whether to prosecute, just like in any other case where there are potential fact questions. And then it will be up, of course, to the judiciary to decide whether, in fact, there was such a violation. But I think that the standard itself is quite high, and we can expect, the actors in our criminal justice system, the courts and the prosecutors to, act as they normally do, and that is to bring charges in good faith and find the facts consistent with their fact-finding role.
Okay, thank you.
Thank you.
Mr. Partlow.
Thank you, Your Honors. Michael Partlow here on behalf of the appellee Lamont Rue. Your Honors, there's one thing I'd like to clear up before I begin, and that is actually what's before the court. I don't recall which one, but one of the amicus briefs argues that the only issue before the court is the certified conflict. That is simply not true. If you look, there are two case numbers. There is a certified conflict case before the court now, and there's also a jurisdictional appeal, which was granted. So basically what that means is anything that's relevant to the proceedings below is fair game in this appeal. Your Honor, the 11th District decided this case under a best case scenario for the state. Now, when you're looking at the due process concerns, which I'll address later on, I'm not sure that that's exactly the approach that should be taken. But the 11th District found, even under the state's best facts, the appellee, or the appellant in that case, the appellee in this case, wins. Your Honors, we have all sorts of cases where we talk about legal fictions. This is the first case I've ever had where I think we're actually talking about legal fantasy. And that's because certain things that the appellee and the amicus rely upon simply didn't happen. In this case, there was literally no due process whatsoever, no notice. There wasn't even a motion or any pleading filed seeking a revocation. There was simply a warrant issued. That's it. And I think where that comes into play, if you look at paragraph 28 of the Court of Appeals decision, you'll find 4 questions that the Court of Appeals specifically opted to not decide because it didn't need to. The state lost without answering these questions. But should this court go any other direction, then those questions will have to be addressed because they're all due process type of questions.
But here, he knew that he had absconded, and there was he was in fact had a violation for failing to report, right? So those issues that doesn't seem to be a problem in this case, does it?
Yes, it does, Your Honor. What do we have before us showing he knew he absconded? And I would argue to the court, frankly,
well, but he was charged with failing to report, right? Wasn't that the?
No, there was no charge. There was a warrant.
Well, he had a probation violation. That's a charge.
Well, no, there was no charge, Your Honor. Look,
there was no probation violation. There was no warrant issued for his arrest after he failed to report. What's that?
There was a warrant. That's all. There was a warrant to pick him up. That's all. That's all that was ever filed in this case. And the reason I said that I feel like we're talking about legal fantasy, there was absolutely no allegation, formal allegation made or finding by the trial court that he had absconded and that tolling was an issue. And that's where
So when he pled guilty in April 2017, what did he plead guilty to?
In April of 2017?
Yes.
In that one moment, Your Honor. You know, Your Honor, that one here, again, it's vague. It says various violations, one of which was keeping up with his restitution. What the others were, Your Honor, I honestly don't know, and I'm not going to enter the world of fantasy myself.
Well, wait a second. I mean, so he was never given notice what he was charged with?
No. Let me explain, Your Honor.
There was no probation violation issued.
No, not a document indicating that, like there was in the Summit County case of Meyer. No, nothing like that was issued either.
I'm surprised that no one raised that.
Well, you know, Your Honor,
if that's true, then that's a problem, obviously.
Yeah,
you can't be convicted of a probation violation without being told what the violation is. So,
initially I was very surprised, as Your Honor appears to be. After I thought about it, though, in a way, it kind of made an odd sense. What the trial court did then was say, okay, we've got these violations. The first time I'm talking about, we've got these violations, and so I'm going to extend community control until the restitution is paid. Well, let's think about that. Let's say the entry goes on a day later, 2 days later, whatever. And then a week after that, Mr. Rue paid all his restitution. He would arguably be able to go in and say, hey, I shouldn't be on community control anymore at all. That may have been what was in their mind. I can't say. I try not to delve into what's not in the record, and that's not in the record. Your Honors, I think the state and the amicus in this case are trying to do a couple of things that are really dramatic, and they're sort of hidden. First of all, the first time that tolling was brought up was in the 11th District. It was not brought up at trial level at all. The state was absolutely silent. The trial judge did not use the word tolling or in any way contemplate that. Now, there's a well-settled appellate rule in many, many cases. It's been used against me on various occasions in appeals, criminal appeals especially. You don't bring it up at trial, you've waived it. And I think that rule is under attack in this case.
Let me ask you about that. Well, when the community control was extended to pay restitution, did his counsel bring it up? Did they say no, you can't do that?
I do not believe so. Okay. But here again, I'm not sure that's in the record. I don't want to be misleading. The other big thing I think that
Counsel, let me ask a different question.
Yes, sir.
Assume a 3-year community control. After 2.5 years, the defendant leaves the state. Okay.
Okay.
If you want the hearing to take place before the 3 years is over, are they going to try him in abstention?
Well, Your Honor, first of all, let me clarify one thing. We're not saying the hearing has to take place before the community control's over. We're saying the charge has to be made before the community control's over. So we have no problem with the hearing.
But you were arguing due process, if I remember correctly.
I'm arguing due process, yes, sir.
And was that raised at trial? I know jurisdiction. I couldn't find anything on due process.
No, and it wasn't, and I'll tell you why, Your Honor. This is a bizarre appeal. I assume, I've never worked at the High Supreme Court. I did work at the 9th District, but I assume you guys have everything, including the 11th District stuff. If you read my brief, you'll say, okay, here's our argument. The first time ever that the concept of tolling comes up and the due process implications of that is in the appellee's brief in the 11th District. Then in my response brief, which is actually larger than my initial brief because this new issue has come up, is where you first see that. So I guess what the state wants is for a criminal defendant to somehow peremptorily make arguments at the trial court level that the state has never brought up, nor has the trial court. I'm not sure that that's fair, Your Honor. I think the other big thing that's going on here, the state relies heavily upon Meyer and wants you to affirm Meyer. Well, in fact, they don't. They want you to expand Meyer. Nothing in Meyer says that there's an automatic tolling that starts when somebody doesn't appear for one community control meeting with their probation officer. Myers didn't say that at all. The other big thing about Meyer is Meyer has oodles of due process. There's a motion filed specifically delineating what the probation violation is. There's an evidentiary hearing. As I recall, first the parties went before the trial court who decided, wait a minute, we've got some controversy here. I need a hearing. And a subsequent hearing, I believe the next day, was scheduled and evidence taken. And that's when the trial court made a specific finding that there had been a tolling. So that's why I
Counsel,
yes.
You're saying here that your client never received a written document notifying him that he was being charged with a violation of community control.
Yes, Your Honor, I am. The record does not reflect that he ever did. In fact, that was noted by the 11th District. If you read the questions.
So apparently the probation officer went to the court, complained about your client, and the court automatically issued a warrant. Is that?
Yeah, there's a form they have, at least in Trumbull County. I can't speak for other counties, where the probation officer essentially asks for a warrant and they're always granted. Yes.
So
Okay,
he
so
did
there
file
was
something with the court, the
the
probation officer.
probation officer. Yes, a request for a warrant.
And in that, was it delineated why he needed the warrant?
I believe a failure to appear was listed. Nothing about tolling was discussed.
Wasn't that just what I asked you? And you said as long as some charge is brought?
I'm sorry, Your Honor. Let's
Well,
back
when
up.
I was
I must
asking,
have misunderstood.
when I was asking you about being, a revocation hearing and abstention, you said, no, just some charge has to be brought. Okay. Isn't that what occurred here?
No, Your Honor. Let me clarify. Perhaps my answer was bad. A warrant is a warrant. It tells you to pick them up, and obviously any trial judge would know why. Okay, well, probation violation. Okay, it may or may not say what. I honestly don't know. But in the other cases, for example, in Meyer, there was a formal request for a revocation of probation filed, and I use the term, it's community control, I know, that the defendant was served with and that the trial court decided it needed to conduct an evidentiary hearing about. None of that happened here. That's pure fiction. It just didn't. Your Honors, this case presents a lot of issues, and some of which you may delve into, some of which you might not decide to. One of the things the 11th District didn't decide is whether or not a warrant, the issue of a warrant without more, is sufficient notice of a probation violation to satisfy due process. They specifically said, we're not deciding that here because we just have such a mess. I mean, it's not going to matter, okay? But I think another issue, which the court may or may not address, is what is absconding? I was a little bit surprised to find there's not a whole lot of law on that, okay? Reading the statute, it doesn't say what absconding really is. There was one case by this court, and I apologize, I could look quickly and find it, but there's a case where this court in a per curiam decision basically said that either absconding or leaving the jurisdiction would be grounds for revocation of community control. The issue before it was not really what is absconding. There was a dictum in it, I believe, that said something like, well, not showing up is absconding, but that really wasn't the issue before the court. The issue before the court concerned the statute and whether you had a failure to needed to have a failure to report and leaving the jurisdiction, or whether they would be looked at separately. The court decided that they were separate. You didn't need both. So what is absconding is an issue here. If you look at other jurisdictions, if you look at Black's Law Dictionary, that sort of thing, it seems to be generally agreed. You need something more than just not showing up for a meeting with a probation officer. You need to be actively hiding from the court. One part of the testimony, if you read the 9th District decision in Meyer, part of the testimony in that case was the patient officer actually testifying about efforts she made to find the defendant. I did this, I did that. And none of that occurred here. In fact, the state waited months and months to even file anything, and then they just filed a warrant. Honestly, I don't understand how due process could possibly decide, allow that. According to the state's position, they could wait 5 years to file anything. Then the defendant could be brought in and determine whether or not any kind of tolling event occurred 5 years ago. Here again, I believe that goes into some of the questions not answered by the 11th District in this case. Your Honors, I see I've got like 10 seconds left. I appreciate the time. It was an interesting experience. I've never done a video argument like this before, and I wish you luck in your deliberations.
Thank you. Counsel, you've used your time. You may take a minute.
Thank you, Your Honor. Since we are out of time, I will just quickly ask that this court reverse the 11th District Court of Appeals decision, because unlike
Counsel,
Meyer,
what about the fact that Mr. Rue never received the formal notice of violation?
considering the habeas for his arrest was filed after the November 20th adjusted term for that first violation and tolling period, he was on notice about the violations. And in this case, he pled no contest to the violations. Those are contained in the probation status reports. Those are the violations that he was before the court. And that included the period of absconding, which was several months. So unlike Attorney Partlow's example, where the state sits idly by and waits 5 years, that is not what happened in this case. He absconded, and a few months later, just 5 weeks, less than 5 weeks, when that term would have ended absent tolling, the court initiated the warrant. This was not in a waiting, sitting idly by. And in fact, if we look at it that way, we would be awarding a wrongdoer for his wrong. The statute's clear, the tolling is attached to the defendant's actions, and the 11th District Court of Appeals completely ignored that. And they stripped the trial court's ability for even determining if a tolling event extended the term. And that's why we have
So you're saying in the first violation for not reporting, that was also at the end of his 5 years, there was a warrant issued to pick him up, right?
Yes.
Was there also a probation violation paperwork filed here?
So the capias is what initiates the revocation proceedings. I'm assuming when the defendant is arrested on the warrant, it is for the probation violation.
And that was found to be lack of payment of restitution.
That's incorrect, Your Honor. It was for multiple violations, which included the failure to pay restitution, but also included the failure to report to his probation officer for several months. So at the time, that would have been
specifically stated to the court by the court at the time of finding of the continuance of his probation.
Well, as the 11th District Court of Appeals noted in its appeal, that part of the record, the transcript from that hearing was not given to the court. So we don't have the transcript of that hearing, that first hearing. However, the transcript from the second hearing indicates the trial court said, I extended community control sanctions for multiple violations. It did not say it was solely on the basis of restitution.
But it did mention the restitution.
I don't believe restitution was mentioned by the trial court. I believe it was raised by defense counsel, and the response by the trial court was that it was for multiple violations.
Thank you.
Thank you, Your Honor.
We'll take the matter under advisement. You'll be notified of our decision. Marshal, will you adjourn court?
Hear ye, hear ye, hear ye. This open session of the Honorable Supreme Court of Ohio now stands adjourned.